Starting, okay. So we're starting. Good afternoon, and welcome to our lobby talk on transparency framework in the EU with João Teixeira de Freitas, manager of the Society of European Affairs Professionals. Well, in first place, I would like to thank you, João, for accepting our invitation. Both associations, as you know, have a lot of things in common. We both belong to PACE, PACE, the Public Affairs Community of Europe, and we share objectives and values. For example, both associations work to develop and promote a public affairs profession that contributes to foster better policy outcomes with the transparent and ethical participation of different public affairs and European affairs professionals. Basically, we have organized this webinar today because many APRI members, which also work at a European level, just a second, because there's people connecting and I have to allow them.
No problem.
Sorry, as I said, well, we have organized this webinar today because many APRI members, which work at European level, find abysmal differences between the European and Spanish institutions when lobbying, no? For example, in Brussels, when a legislative package is published, in addition to the press conference, several documents that are published, including the bills and the scientific and working documents that have supported the development law. In Spain, the transparency procedures and participants process are far away from the ones developed in Brussels. In most cases, you have a good friend in the public sector, or you stay out of the information. In other words, in Spain, there's a lack equal treatment. We can say that there is a lack equal treatment, and it is more difficult to access to information. We have seen this happen during the coronavirus crisis, especially when with the last-minute decrease approvals and the spreading of institutional fake news. In this context, we are here today with João, who will explain us the transparent framework procedures in Brussels. João, just a second. João Teixeira de Freitas has been the manager of the Society of European Affairs Professionals since September 2019, where he has been monitoring the files on transparency and the regulation of the public affairs sector. With a legal background, he obtained a double master degree in European and transactional law from Católica Global School of Law, Lisbon, and King's College, London, where he researched topics about the transactional regulation of corporate social responsibility. He moved to Brussels in early 2019 to work as a legal advisor for a law firm and to direct the operations of the Belgium-Portuguese Chamber of Commerce. Most recently, he has started providing independent consultancy service on public affairs matters to various clients. Well, once again, João, thank you very much for participating today in this webinar, and thank you for sharing with us all your European experience. Now I give you the floor, and well, after this exposition, I imagine you can inform APRI members on the special benefits they will receive for attending this webinar. So once again, thank you and welcome.
Thank you very much, Irene. So first, I would like to thank APRI and Irene in particular for having invited me. Obviously, here at CEAP, just to give you a little bit of context, CEAP is the first association that was created to represent interest representatives as a whole back in 1997 in Brussels. And we have been working since 1997 basically towards the professionalization of the sector and towards empowering our members in order for them to become better public affairs professionals. And without further ado, I will do a small presentation on the current debate on transparency and lobby regulation in the EU. This is the title. And I would like first to start by saying, what are the objectives of this presentation? I think this will make it much clearer for you of what I intend to do with this, and perhaps you will be able to better assess if you accomplish these objectives by the end of the presentation. So first, I want to provide you with an overview of the current transparency regulation in the EU and how this regulation came to be. Then I would like to take stock of the current state of play regarding the transparency debate, because it's something that has resurfaced in the Brussels bubble, and actually negotiations on this subject are being pushed forward again now by the institutions. And I would also like you to get familiarized with technical discussions around this subject. I think this is very important for public affairs professionals in general, because this allows them basically to know what's being debated regarding this subject, and therefore allows you also to better lobby your own government in favor of more transparency. So first, I would like to briefly explain what is the point of the departure for transparency in general, and where is the transparency framework inspired. So first and foremost, transparency, integrity, and accountability are essential prerequisites of a democracy based on the rule of law. Essentially, they promote good governance, they build trust in the policy-making process, and thus they enhance the legitimacy and the credibility of public institutions. And of course, they are also extremely important tools in preventing corruption and bad governance practices. Transparency requires the disclosure on information on policy making and spending, while ensuring citizens' access to such information. So this is therefore a key element to build, as I said, the accountability and trust in decision makers. So in this respect, monitoring and oversight are very important, because they are the tools that allow us to basically control public officials and to guarantee their accountability. And participatory and allowing people to participate is essential in this process. And the EU basically started developing the conversations around transparency based on constitutional principles. And I have enumerated a few here in the slide, who actually are the constitutional principles of the EU that base all the legislation that comes out around transparency. And I think this is very relevant, especially for public affairs professionals that are trying to lobby their own governments regarding the improvement of a transparency framework. It's important to go in their own constitutional texts and try to find these kind of presets that basically set minimum legal standards, and can actually be the base of many legal arguments to persuade governments into basically approving more robust frameworks on transparency. And also, this is a good opportunity for public affairs practitioners and firms in general to also act on a sort of perspective of value creation that goes beyond creating value merely for our clients. When public affairs professionals are fighting for more transparency because they feel it's useful, it's also because they feel it benefits the society as a whole. So it's thus a good tool for public affairs professionals to go to enhance their value creation beyond value creation just for clients, but also for the society as a whole. Now, I would like to basically do a sum up of what are the current rules and tools that the EU has at its disposition regarding transparency. So first and foremost, disclosing information on interactions with lobbyists. And this is basically assured through the transparency register. So the EU institutions interact with a wide range of organizations representing specific interests. And this is actually a legitimate and necessary component of the lawmaking process, as it ensures that the EU policies and legislation ultimately respond to the citizens' needs. So dialogue with stakeholders increases the availability of the expertise that public officials have at their disposal. And this is very important for them to create evidence-based legislation, basically. And the worry here is that in order to establish this dialogue, we need to establish it in a transparent manner to allow for a proper scrutiny of the dialogues that are going on and to avoid misconduct of the people that are having these dialogues. So for this purpose, the parliament started in 1998 in 1996 by establishing the first register for interest representatives. And at the time, this was in a very embryonic stage. It was a register just for people who wanted to gain access to the parliament buildings and to actually enter and have meetings with specific MEPs inside of the parliament. Then in 2008, so many more years later, the Commission finally followed through and approved their own transparency register. And this was following one initiative from 2005, which was called the European Transparency Initiative, launched by Sim Kallas at the time. And basically, after the Commission launched in 2008 their own transparency register, then the Commission and the Parliament started talking more about maybe merging the two registers in one to make it a broader tool that is more useful for all public affairs professionals and citizens in general. And therefore, on 2011, they introduced the regime that we currently have, which is the transparency register based on an interinstitutional agreement. So there was an interinstitutional agreement approved between the European Parliament and the European Commission to create this register. And in 2014, the provisions were revised and the Council became an observer of this register for the first time. So, and what does this register really allows us to see regarding the interactions with lobbyists? Basically, the current rules on the European Union, they are different depending on the institution that we are talking about. And for example, whereas for the Commission, rules are tighter than for the other institutions. So for example, for the Commission, there is an obligation where commissioners and senior management staff, so members of cabinets and director generals, actually have a legal obligation to report all the lobby meetings that they have. And they can only have lobby meetings with lobbyists that are registered in the Register of Transparency. So these are the tightest rules that we have regarding interactions with institutional policymakers. For the Parliament, actually this came much later. So even though the Parliament always had a provision that encouraged MEPs to meet only with registered lobbyists, this was never a legal obligation. But since the beginning of 2019, the Parliament's rules of procedures were reformulated, and now actually all the rapporteurs, shadow rapporteurs, and committee chairs in certain files are forced to publish their data on lobby meetings, basically. So this is what we have regarding the disclosure of information regarding interactions of lobbyists with public officials. But we also have a very big strand of regulation relating to integrity and standards of conduct, which basically comes in the form of codes of conduct. And regarding the institutions, we have fairly developed codes of conduct, both for the Parliament, for MEPs, and for commissioners. We also have a general code of conduct for the EU staff as a whole, so all the officials that work for the institutions but are not necessarily in any major position. And we only don't have a code of conduct for the Council. And that, as a special reason of being, is that the people who are represented in the Council are actually the ministers and the heads of state of individual member states. And thus they are bound by rules enacted by their own member states on these questions. It doesn't happen all that they are bound by codes of conduct like in the European. It doesn't happen always that they are bound by codes of conduct like in the European Union, but some of them are bound by rules coming from their own countries. And these rules basically, they set up a set of principles under which public officials should act on. These principles include disinterest, integrity, openness, diligence, honesty, accountability, respect for the reputation of the institutions. And they also include a very important subset of principles relating to conflicts of interest. So there is a broad regulation regarding conflicts of interest, and actually, for example, MEPs, whenever they go into office, they are forced, actually legally, to submit a declaration of their financial interests prior to taking office, for example, in the European Parliament. And also, these codes have created also interesting structures, both within the European Parliament and within the European Commission. Because in these two institutions, we actually have in the Parliament an advisory committee, in the Commission an independent ethical committee, which are there basically to monitor the application of these codes of conduct. So whenever there is a problem with these codes of conduct and there is a complaint regarding the actions of a certain member of parliament or personnel from the commission, then there is a body specifically created for this purpose that is going to analyze and view up to what point the actions taken by public officials were in accordance with the obligations that the code of conduct sets for them. So this is also another way that the European Union uses to regulate transparency and behavior on the part of public officials. And then we have another big branch of the regulation, which is basically the access to documents and transparency of the legislative process. I think these are basically the three big branches of transparency regulation. And regarding access to documents, this is obviously an essential component of transparency policy and lawmaking. And actually, the Article 15.3 of TFEU grants EU citizens and residents of EU member states the right to access documents of the EU institutions. And this is a very important right, and it's a right that is in the constitutional documents of the European Union. And therefore, actually, it has been interpreted very narrowly by the European Court of Justice. So in fact, now, and especially after this regulation, there is a regulation which is Regulation 1049/2001, which for the time regulates this in depth. And basically, the exceptions that are set there say that the European Union can only sort of negate the access to documents and information if it's due to a need to protect the institution's decision-making process and the public interests as regards to international relations, public security, and military matters. So as you see, as three very specific points, and in all the rest, the European Union is supposed to keep their doors basically as open as possible. And especially for us public affairs professionals, this is very important because often is after these political meetings and the launching of initiatives that we go and we need access to the documents to analyze them and actually realize what is going on and what's going to be defended, what certain parties are discussing. So this is a very important tool for us, but also for the citizens in general. There was a tentative to basically review this regulation and make it sort of even better and enhance the access even more, especially in what regards documents of the Council. But unfortunately, this initiative in 2008 did not pull through, and thus the Council remains to this day still a very opaque institution, and there are certain documents that they don't release on a voluntary basis. But nowadays we also have an important tool which sometimes grants us access to these kind of documents, and it's useful to know. There's a website called asktheeu.org. And in this website, any citizen can go there and make a request for a document. So if you know that there was a political meeting on a certain file that took place in the Council last week, you could go to this website and ask them if they could share with you the documents that resulted from this meeting, the agendas that were prepared for this meeting. And actually they have a 15-day deadline to respond. And in most of the cases they do respond, and many of the documents that we get access to are coming from there. Actually, in order to create this presentation and to present you the current state of the debate, this is where I obtained most of the documents, is from this website, asktheu.org. So also, just another note regarding the Council, which I think it's important to make, is that in March 2017, the European Ombudsman actually opened an inquiry into transparency of the Council's legislative work. And the result of the inquiry is that the Ombudsman found that the Council's current practices constituted actually maladministration, and recommended that member states' positions be systematically recorded, and that the Council should develop a clear and publicly available criteria on how it designates documents as not to be published. They usually have a word which is limit in these documents that are not supposed to be published. But so far, things don't look very, very favorable in terms of improving the transparency in the Council. And now I have compiled here in this slide a little sum up, basically, of the common challenges that are faced when trying to regulate the subjects, and the corresponding principles that are in general adopted to solve these problems. So in first place, we have general mistrust with regard to lobbying and asymmetric information, and this can be solved precisely with transparency, by disclosing the amount of expenditure that people have on lobbying, by disclosing the meetings and the purposes of the meetings. This is the corresponding principle that was adopted basically to mitigate this problem. Then there is the general risk of lack of ethics in lobbying. And for this, we have all these codes of conduct that contain a series of general guiding principles for ethical behavior. I actually forgot to mention, but APRI probably also has a code of conduct for their members, and CEAP as well. We have our own code of conduct for our members. And actually ours even goes a little bit broader than the code of conduct of the Transparency Register, because it also sets standards for ethical behavior and not only for disclosure and transparency. Then we have the problem, obviously, of conflicts of interest, acceptance of gifts, and corruption. And then these are the principles that are used to deal with this problem. So independence, objectivity, accountability towards citizens and one institution. And then another very important problem, and this one comes on the news a lot, especially in the European bubble, which is the revolving doors problem. This occurs whenever there is someone from a lobby group moving to the institutions, or someone from the institutions moving to lobby groups. There is potential a conflict of interests here, in the sense that perhaps the people that do this will have privileged access to their former colleagues, and thus a privileged position to influence the decision making and policy making. But this, in theory, can be solved with rules on post-term office. So the European Union has a series of rules that actually prevent European officials from taking certain kinds of jobs after holding office. Another instrument that is used to regulate this, for example, is the use of transitional allowances, which are effectively payments which are made for people who held public offices after they left the office, in order to not incentivize them to search for another job, basically. And this also exists in the institutions, and it's proven to have success in terms of controlling this problem of privileges and privilege access. So now, moving on, I would like to present what is the current state of play of the debates of transparency in the European Union. First, there is this Commission proposal on establishing a mandatory transparency register. And this is already from 2016. So indeed, we are already in 2020, it's 4 years later, and the negotiations were not fruitful at all. Meanwhile, in the past legislature, they decided to stop the negotiations because we were going to have a new parliament and a new commission this year. So therefore, they felt that it was not very appropriate to try and push them forward. But now that the new parliament and the new commission are already in office, they have once again inserted this as a policy priority. And actually, Commissioner Vera Jourova said publicly in her mission statements that she is going to push this idea forward. So the kickoff trilogue meeting of this file took place actually on the 16th of June, so not very far from where we are right now. And the head negotiators from the European Parliament were already nominated. We have Vice President Katharina Barley and MEP Dan Nuterhubner, which was already the negotiator in the last round of negotiations. And also the minister delegate from the Croatian presidency, Nikolina Brnjak, and of course the commissioner Vera Jourova. So it's a full female panel negotiating this transparency subject on the EU. And they have already planned technical meetings in July and a second political meeting in September. And basically their idea, even though I personally think it's a bit perhaps it's going to be hard to get it done by then, but their idea is pushing for a final approval of the mandatory register until the end of 2020. So what is agreed upon? I think it's useful perhaps to start on where the institutions are not discussing and then move to the points that they are really discussing at this time. So first, the three institutions affirm that transparency and accountability are essential to maintain the trust of European citizens in the legitimacy of the political, legislative, and administrative processes in the European Union. Then, all of them recognize the necessity of establishing a mandatory register. Mandatory, why? Because it's mandatory because it makes certain types of interactions conditional upon prior registration, in the sense that if you are not registered, then you would not be capable of having certain types of interactions with policy officials. Currently, the current register that we have is already like this for the Commission, in the sense that for the Commission, their own internal policies mandate that they only meet with registered lobbyists. But this is an internal policy of them that is not applicable, for example, to the Parliament. So parliamentarians are free still to meet with basically whomever they wish to meet. And they don't even have to disclose forcibly unless they are rapporteurs, shadow rapporteurs, or committee chairs, as I have referred previously. And they also, and then here is basically the things where they've agreed upon. So the purpose and scope of the agreement, they already agreed on most of the definitions that are going to be put in there. I'm going to speak a little bit more on this right now in the next slide. They also agreed that on the bodies that are not covered by the agreement, nothing changes that much from the previous framework. Criteria for eligibility and registration also pretty much remains more or less the same. Establishment of a management board and a secretariat whose resources are provided by the three institutions, and along with the general tasks and powers of this secretariat. This is already agreed by the institutions, and the possibility of voluntary involvement of other EU institutions or bodies, offices, and agencies in this register. So this is basically all what they've agreed on. And now I would like to move to the part where they don't agree on, and it will perhaps be difficult for them to agree. And I will try to do my best to explain why. So, but first, what is improving with this new framework that they are trying to instate in the European Union? So first, they changed the definition of lobbying. So now we have a more clear definition of lobbying. Before, I don't know if you are aware of this, but before, lobbying was defined, it had basically a very, very broad definition, which stated that it was all activities that directly or indirectly try to influence policy making and policy creation. So this definition, even though it's good that it's broad, but then it creates some problems in the sense that, for example, imagine that you are a public affairs professional and you are contacted by some media outlet and you speak to them about the policy positions that you want to take on a certain matter. In a sense, it could be said that you are indirectly trying to influence the policy making procedure, because probably the officials will read that newspaper, but also it's not a direct interaction with the public officials. So there's kind of a doubt if this really constitutes lobbying or not. And so this is what motivated basically the change in the definition. So now the definition, the proposed definition is now based on interactions. So this suggests that actually there needs to be a closer link between the interest representative and the public official, and there needs to be an actual interaction to warrant for the public affairs professional to be registered. Then we have an exemption for local and regional governments. This was not very clear from the outset in the previous framework, and this led to some strange situations where you had, for example, municipal or regional bodies opening offices in Brussels and then registering themselves in the transparency register as if they were lobbying the institutions. But for all purposes, it is understood that an entity that is democratically elected cannot be treated the same as an interest representative that is defending their own interests or the interests of their clients. And thus, they were exempted from this new register. Then there is all sorts of improvements regarding data disclosure. They improve a lot on the definitions. Sometimes in the previous register, it was not clear if, for example, if I am a company in the energy sector that hires a consultancy firm to provide services for me, should I be the one declaring this? Should they be the one declaring this? Then they adopted this policy of double counting effectively. So their answer to this was yes, you both should declare this. Now with the new register, this is made more clear because they adopt more clear definitions regarding what a client is, what an intermediary is, and what an interest representative is. So an interest representative is probably someone who is representing their own interests, either as a member of a trade association, for example, whereas an intermediary would be the typical public affairs professional who is representing the interests of their own clients. And the clients are, of course, the people who hire someone to represent their interests together with the European institutions. Then we have a number of improvements regarding the enforcement of the framework. So in a sort of way, the secretariat that is handling the transparency register will be made bigger, and it will have a little bit more teeth. They will also analyze the entries in the register ex ante, because right now this is done basically by a computer program, and sometimes things fail, and the analysis is not as detailed as it should be. And so they are improving on that, and also improving on creating a stronger management structure basically for the body as a whole. Now, for the key issues that remain basically unsolved. And this is, I think, where the heated debates are going on, basically. And there is one very, very big debate. And this was actually the main reason why the negotiations failed in the last round of negotiations, which is this question of taking into account the specific nature of each institution. And this is very much related to the conditionality principle. So just for you to understand better, I will give you the extremist of the positions, which is the one of the council. The idea of the council for establishing a new register is basically one very simple, is that there will be an interinstitutional agreement in 3 parts where each institution will define for themselves what are the interactions that will be subject to registration. So you can see the kind of problems that this will create, because then you have to consult 3 different documents, and you might be required to register for some interactions with the council, for example, and not be required to register for some interactions with the European Parliament. But basically the council is really taking a strong stance here, in the sense that they really want to be themselves the ones deciding what interactions are they going to submit to the conditionality principle. And related to this is also this question of what are meetings. So in the Commission's definition, a meeting is an encounter between a public affairs professional and a public official, no matter where it takes place. Whereas, for example, for the parliament and for the council, they have this view that meetings are only encounters taking place inside the premises of the institutions. So if you are in Place du Luxembourg having a coffee with an MEP, this would not be considered a meeting. So they were debating on this a lot, and I think this is what failed the negotiations in the last round. And now I spoke to personnel from the transparency unit in the commission last week, and I think that by now they are convinced that they will have to basically change the text and make some and concede some of the points that they had originally planned if they really want to bring on board the other institutions for this transparency register. Then we have obviously questions relating to the functioning of the JTRS. These are all these beautiful questions regarding who manages it, how is it funded, and so on. And there are still a lot of points here which are not defined. Actually, the proposal of the Commission in the articles that speak about this states that there are still further decisions that have to be made. So there's still a lot here that possibly can complicate the negotiations. And then we have a question of legal architecture, but now to a lesser extent. I just put this here because I think it's relevant, especially for public affairs professionals. I would like to explain to you what was the debate back then. This is not the debate so much now, and why this is important. So there were basically two options to make the transparency register. One was doing an IIA, so an interinstitutional agreement, which is an agreement between the institutions themselves, but that has a very important particularity, which is the agreement can only bind personnel from the institutions, cannot create legal obligations for people who are external to the institutions. So for lobbyists, for example. And if they were to do it this in another way, using, for example, the clause 345, which is the clause on implied powers. If they were to approve a legal instrument via this clause, then actually they would be able to impose obligations on lobbyists and on individual citizens, and therefore the instrument would have the potential to be actually much more biting and have much more teeth than it actually has. But the problem here is that this requires unanimity in the council. And it's already very hard as it is with the council right now. So that's why in the end, the commission opted for the IIA. And this leaves us with the situation where the instrument only creates obligations for institutional personnel. And the only consequence that lobbyists may have is that if they don't respect the rules, they can be expelled or suspended from the register. But this is not a legal obligation per se, it's just the loss of a benefit that was attributed to you. Now, this is a little bonus, basically, for this session regarding the subject of transparency. So this is a little comparison we've done this week. It just goes to show that that basically the gross number of lobby meetings with the European Commission, if we compare comparable periods for the Juncker Commission and for the von der Leyen Commission, we see that in the first 3 months of the commissions, so before Corona times, we see that the von der Leyen Commission was actually 15% more meetings than the Juncker Commission. But then now, after the first 6 months, so now with Corona, von der Leyen Commission is actually down 24%. It's just a curious set of data. I think, of course, more in-depth research would need to be conducted in order to really attribute this to the COVID situation. But nonetheless, it's an interesting data to show how COVID has impacted the number of meetings that there are going on. And also we have this. So in May 2020, following the outbreak, the Parliament approved a provision to improve the online tool used to publish information about these lobby meetings when they are held via video conference. because the MEPs, they have a tool where they go and they enter the details of the meeting online, but there was no option basically to say that the meeting was held via video conference. So now they do have this option, and this makes it clearer also for the parliament that for all purposes, video conferences are to be considered meetings. And then with COVID, we start to basically raise all these kind of interesting questions, which are, for example, is a phone call a meeting? If I call a public official, is a phone call a meeting? So the guidance that we have on this from the European Commission is that informal calls are not meetings if they don't allow for an exchange of views or information between the participants. So if it's just a call to remind, please answer my email, or do you have an answer for me already? This, for all purposes, is never considered a meeting. But also raises other questions, for example, which is other questions relating to the GDPR, because now many of these very important lobby meetings, which are never recorded, it's sort of taboo for a lobby meeting to be recorded, are being held online. And there is no effective way of controlling if one person is using a software to record their own screen. So maybe we will see some problems arising from this via the future. And also, of course, nowadays, according to GDPR, if you are recording, people do have to give specific consent to that. So now for just a summary slide to wrap up in my 45 minutes that were allocated, and then I would be more than glad to answer questions. So basically, COVID-19 appears to have slowed down the normal functioning of lobbying, given the current meeting metrics. Voluntary disclosure is on the rise by MEPs and certain council states. And this is also why they are moving these negotiations again forward, because there was a push, there was a sort of, it's step by step. So slowly, step by step, individual member states are starting to take initiatives to make themselves more transparency. We saw this, for example, with the Finnish and the Croatian presidency assuming commitments to disclose their lobby meetings. We see, for example, the Italian permanent representation in Brussels that launched recently this whole transparency package for their offices, where they also report the lobby meetings that they are having. So in a sense, this subject starts to be more and more normal in all member states, and all start to have kind of policies to improve their transparency frameworks. The problems with the current dossier are driven by institutional privilege, not interest representatives. So this is not being held back by lobbyists in any way. Actually, most of lobbying organizations in Brussels are for moving this forward. And it's just a matter of the institutions themselves coming to an agreement. And then changes continue to be driven by transparency, not ethics. So even though there was this opportunity to instate a more serious regime that would perhaps create legal obligations for people outside the institutions, this view this legal way was not adopted. And so the current scenario continues to be on disclosure and transparency, and not so much on what constitutes ethical behavior for a lobbyist and the way in which a lobbyist should behave before the institutions. So this was it. I hope you liked it. Now I'm glad to answer any questions that you may have regarding this. I would also like to inform you that all attendees of this webinar and APRI members are offered the free CEAP membership until the end of 2020, in case you want to keep in touch with these subjects. Hopefully, given the current plan on negotiations, if it becomes true by the end of 2020, we will have already a new mandatory transparency register. And thank you very much for your attention. I hope this is also useful knowledge for you to lobby your own governments and to promote the development of transparency frameworks in Spain.
Okay, well, thank you, João. It's very interesting to understand how things work in Brussels. And even the EU transparency model is not perfect. In Spain, we are way far away from the EU model. And we hope that at least we reach a basic transparency model. Well, as you know, we have been working on over nearly 10 years on trying to have a Spanish, well, a transparency register here in Spain, and we continue working on this. So thank you very much for your presentation, all the information, and for especially for the benefits now you are giving to the APRI members to give them the possibility to engage to SEAP, no, in this second semester. So now we give floor to the questions. To the questions of the participants, and we open the debate. So please, I think if you can write your name in the chat so I can give you floor. Let's see if we have people. Any questions? Well, if you want, well, I can start with the first question. Here we have Victoria. Here, Victoria. So Victoria, if you want, you can put your microphone on and on your camera, and you can make the question.
Yes, hello. Well, first of all, thank you very much for such an interesting presentation. I work in Brussels myself, and I was wondering, and I would like to know, what is your perception on this new reality post-COVID? You spoke about it, about the fact that now most of meetings are held offline, of course, and I would like to know whether you think that it's gonna, you know, the lobbying action is gonna go back to normal as it used to be, people going in the parliament, meeting MEPs. Is this gonna be a different dynamic, more online and less face-to-face meetings, and how that could influence and change the lobbying actions in Brussels and in general? Thank you.
Thank you very much for your question, Victoria. I will try to answer the best I can, because I think that in fact, the greatest difficulty in answering these questions is the lack of visibility that we have into the future in uncertain times, such as the ones that we are living right now. I would say that for sure in the last couple of weeks, we've seen more movement in Brussels. So there are plenary meetings going on in the council, and Coreper meetings going on in the council. MEPs are starting to get back to their offices as well. But also we've actually seen that the institutions were capable of really quickly adapting themselves to this new reality. So for example, to this example, both the council and the European Parliament have reformulated their rules of procedures to allow, for example, for electronic votings to go on and distance meetings to go on. And I think this was an important step, and on this way, we are already prepared even for a future outbreak if it comes again. Regarding the prevalence of these types of events, I think that at least for the near future, they will absolutely stay, even in an initial phase where people are already going to the office. And I think this is just for the fact that people will also still have this mentality that if I'm invited to go to a big gathering of people, I will probably think twice before going if it's not really essential, and if I can somehow be there virtually through a webcam like we are doing right now. So in this sense, I think that for sure the paradigm is going to change a bit, but also from the feedback that we've been getting from members, and also, I mean, for people in our profession, you know, in-person meetings are the basis of our work, and they are certainly very important. So of course, when this comes again, I think people will try again. One thing I can say to this respect is that, and this actually goes to interacts a little bit with the graphic that I showed on the number of meetings, because the feedback that we receive from our members is that actually they are able to have more meetings, because the institutional officials, now they don't have so many events, they don't have so many meetings of their own. And actually you send them an email, and right now you are able to, fairly easily, to schedule virtual meetings with commissioners and high-level personnel. So in a sense, this maybe is even benefic for some types of meetings, and can give public affairs professionals a more direct access. But then again, it's for the future to tell us what we will see, and but I'm confident we will be ready to adapt. And I think that the way that in which the institutions responded to this crisis, also regarding the transparency matters, for example, when the COVID started, even though for the Commission, for example, meetings through video conference were already considered as meetings even before the COVID, because it's something that the Commission does sometimes with people who are in other countries. But when the crisis started, all the Commission personnel was sent an email precisely reminding them of this rule and stating that now more than ever in this time, we need to take care about this subject of transparency, and we should disclose all the meetings that we are having online. Thank you.
Thank you.
Okay, thank you, João, and thank you, Victoria, for the question. Any more questions from our members? Well, while we have more questions, maybe I will make a question. Well, you said that the council still remains very opaque. Why do you think that? Do you think that they don't have the register because the different member states still don't have that transparency culture? Because as you know, depending on the country, there's countries that are starting to implement the transparency register. There are countries that are far away from implementing it. So why the council still remains so opaque? And another question. When we will be able to see this common EU register of all the European institutions?
Okay, so for the Council, indeed, it's purely driven by member states. So I think one of the reasons why now the institutions as a whole feel capable of moving this forward and approving it until the end of 2020 has precisely to do with what you just mentioned. So whereas 4 years ago when the proposal was launched, there were very few member states who actually had in place transparency frameworks of their own. Now these transparency frameworks start to be more popular, and thus the member states by themselves start pushing these ideas in the council, and therefore there is more of a political will to push this forward. And this leads me to believe that perhaps this time they will succeed. Obviously the Commission will have to make some concessions. It will not be as they wish it was, but in the end I think this will help. And just a small note to know that also is not only the council, and I actually forgot to mention this during the presentation, is that MEPs also, or some MEPs also have a big problem, because they say that due to their mandate, they cannot have legislation impacting the people who they are allowed to meet or not, basically. And this was also a big talking point and one of the big reasons why the negotiations failed in the last round. And so the parliament was also not pushing so much for it, because the MEPs felt that due to the fact that they are directly elected and due to their individual mandate, there could not be a regulation that said, no, you cannot miss this person, the person has to be registered. But in that regard, actually, and I will recommend the reading for any of you who is interested, there is a legal opinion issued by a lobbyist in Brussels, which is also a Jean Monnet professor of EU law, Mr. Alberto Alemano. He has a legal opinion that he had on the IIA for the institution of a mandatory register, where he actually defends that rules obliging MEPs to declare their meetings will not in any way impact their mandate, will actually reinforce their mandate and are proportional to the ends that they try to accomplish. But if you want more information on that, I would suggest the reading. It's a very good legal opinion on this matter. Now, regarding the three institutions being on board, for me, at this point, what I see most difficult is the council. The council is really taking this stance that they have to be the ones defining for themselves what is the code of conduct, what interactions are going to be conditional upon registration. And this is sort of a red line for the Commission and also for the Parliament a bit. And I think with reason, because we all would have to gain in having a solid and all-encompassing framework that makes it easier for us to understand who needs to register. And once you are registered, then you feel comfortable in having access to all of the institutions. But I think that would be the biggest problem. But so I see it in one of two ways: either the council budgets and basically accepts that they have to negotiate something ex ante, or the commission and the parliament will simply say, okay, we accept that the council can regulate these matters on their own, and then we will have it for the three institutions, but not really. So that's my answer.
Okay, thank you, Joe. So it seems that we don't have many questions from the members. I'll make another one while people decide if they participate or not. I've got another question regarding revolving doors. Well, as you know, there are many different opinions on this issue, especially here in Spain. There are many consultancies that that hire people, public officials, once they finish their mandate. So I would like to know which is SEAP's position on this issue, on revolving doors. How strict you are there limits?
Our position is actually very straightforward. We always tell all our members to ask themselves one question: why am I hiring this person? If the main reason is I'm hiring this person because she has contacts inside, then we would advise against hiring, probably, because that's precisely the problem that is created with revolving doors, is the fact that the private sector is hiring people in order to gain privileged access to certain policymakers. On the other end, if you are hiring a person and the main reason why you're hiring the person is because you believe that she is the best that is technically qualified to do this job, and there are very few others that you could pick from, then probably it would be considerable. But always, it's never good PR, you know, to have the name of your company in the news regarding a revolving door scandal. So in every way, we advise our members to always try first to see outside of the institutions if there is anyone capable with technical capabilities for the job. If not, and especially when the main reason for hiring is just getting privileged access, then we would strongly advise against it, basically.
Okay, and another question in regards to the lobbying definition, why don't you, I mean, why have you gone so much in detail on the definition? And you have just, because in Spain we still have the definition of lobbying being a direct or indirect way of influencing, no? Why have you decided to go so deep on the definition? Because sometimes that can bring more problems, more than benefits.
Indeed, it can bring many technical problems. For example, on the part of disclosure, because then people get more questions regarding to what types of revenues and costs can be associated with the specific activities that are considered lobbying, for example. I think a broad definition has disadvantage of making it easier in terms of disclosure, but then it also had some disadvantages, and I think that's why they narrowed it down. So what was understood from the practice throughout these years is that actually there were many people who were, for example, either using the register, for example, for publicity purposes, when in fact they were not lobbying directly to anyone. So they never had a meeting with someone from the institutions, a phone call. Okay, maybe they run a campaign or a media campaign or something like that, but in a sense, this type of indirect lobbying sort of structure that forces certain types of entities who probably are not technically lobbying really to be registered and in the registered and to disclose their information. I think this is a sort of technical point, but it's certainly important. But I think the definition now goes in a good way because I think it provides a little bit more legal certainty regarding what constitutes lobbying effectively. So it's not just because I spoke to a newspaper that I'm trying to influence policymaking. I think influencing policymaking is something a little bit more specific, is having meetings with policymakers, trying to exchange information, trying to exchange views with them. This is lobbying in itself, and all the other things should perhaps be left out. Of course, it's always hard to find definitions for this, but at the moment I think this is where they settled, and it was because they thought that there are many entries in the register of organizations which in fact are not lobbying, basically.
But for example, a grassroots lobbying, I mean, it's like it can be an indirect way of lobbying. So from your point of view, it would be out of the definition, no? In this.
It would depend if they are having interactions with public officials or not. If they are having interactions with public officials, then of course it would be lobbying, according to the new definitions. If they are not, then they would not need to be registered, because also they would not need to have access to public officials. Basically, it's just a sort of way to making a more clear-cut division of the things. But indeed, I think that for most grassroots movements, they do have structures that allow them to interact with public officials, and they are very keen on doing it. So I think clearly for most of these groups, the question, they are clearly lobbying the institutions.
Okay. So John, I think we have finished because we don't have questions from our members. Well, thank you very much. Well, once again, thank you very much for this webinar. It will be great if you can at least share with us the presentation, so I can also share it with all our members in our newsletter. We will also share this webinar that we have been recording. And well, thank you again. If you, as Zhao told you, all the APRI members who have participated today in this webinar have the opportunity to be members of CEAP for at least 6 months, no, for free. And then it's a way that the members can here they are saying thank you. It's a way that they have it's an opportunity they have to at least to know CEAP and see if they're interested in being members of CEAP. So thank you once again, and let's have maybe another webinar in a few months, and to see if things have changed or not, if you have reached a mandatory register or not, and that's it. So thank you.
Thank you very much
once again, and have a nice evening. Bye.
Thank you. Bye.
Thank you. Bye bye.
Bye bye.